Rachel, I've heard the word TUPE, that's T-U-P-E, mentioned by a number of people, but as an employer I really have no idea what it means. Could you explain what TUPE is all about?
Of course I can. TUPE stands for the Transfer of Undertakings, Protection of Employment Regulations 2006. Now what TUPE does is it sets out some quite complex law over what happens to employees where there is one, transfer of a going concern, and two, where there is a contract, well, it's referred to as service provision change. So that will involve transactions like outsourcing, insourcing, bringing the contract back in-house, and also re-tendering exercise where a new contractor is brought in. As I said, it is very complicated and quite a specialist area of law. However, the potential exposure to either a buyer of a business which is governed by TUPE or indeed a new contractor who's awarded a new contract are huge, and it's always advisable to take specialist advice from an employment lawyer who has TUPE knowledge before you proceed.
And was the TUPE regulations, were they introduced to protect employers or employees specifically?
Very much to protect employees.
Okay.
And to be honest, it does cause a huge headache for businesses who are involved, but really it's a very tightly drawn up piece of legislation and very, very important.
Okay. So just explain, Rachel, if you would, what the TUPE regulations actually do. What do they cover?
There's three things. Firstly, it's the automatic transfer principle, which means that the buyer or incoming contractor, as the case may be, takes on all liabilities and obligations towards the employees. If I give you an example, I'm a cleaning company. I have the contract with the local authority. That contract goes up for re-tendering. I lose the contract. Company B, maybe my rival, is awarded that contract. When Company B starts the cleaning contract, they have to, absolutely have to, take on my previous, if you like, employees who were assigned to that establishment and cleaning contract.
So that's a legal obligation on behalf of the incoming contractor in this case?
Yes,
right.
it is. The second aspect of TUPE is the right not to be dismissed in connection with the TUPE.
Right.
So any employees who are dismissed can pursue an unfair dismissal claim. The third aspect of TUPE, if you like, is the obligation on both the outgoing company and the incoming company to inform and consult with employees who may be affected by the transfer.
Okay. So Rachel, how do I know as an employer if TUPE applies to me or not?
Well, TUPE applies where there is a relevant transfer. There are three aspects to that. Firstly, you have to start with an economic entity. Secondly, you have to look at whether there is a transfer of that economic entity. And thirdly, whether that economic entity retains its identity post-transfer.
Okay, I'm a bit confused, I must confess, about what economic entity means. Could you explain?
Well, economic entity is basically a business. In my previous example, it will be the cleaning contract. That on its own is an economic entity. TUPE will also obviously apply where there's a service provision change, which I referred to earlier. That's quite straightforward and normally quite obvious. TUPE will not apply where there is a transfer of shares, which if you think about it kind of makes sense. Where there's a transfer of shares, you know, a sale of shares, the employees are not affected at all. Most of the time they won't even know about it. Nothing changes for them. TUPE won't apply in those situations.
So what actually happens to employees in a transfer where TUPE does apply?
Very simply, if an employee's job transfers, he or she is entitled to transfer with it. The buyer, or the incoming contractor as the case may be, effectively steps into the seller's, or the outgoing contractor's, shoes and takes on those contracts of employment. And most importantly, they cannot change the terms and conditions. If they do, those changes will be void.
Okay, so here's a question I've been dying to ask. As the new employer, what happens if I don't actually want to take on all of the staff of the outgoing employer?
Well, the simple answer is you can do very little about it. If you do dismiss those employees or refuse to take them on, they will almost certainly sue you for unfair dismissal, and they will almost certainly succeed and be awarded a significant amount of compensation.
Okay.
There is an exception to that And it's akin really to a redundancy situation where you can dismiss an employee if it's for what's referred to as an economic, technical or organisational reason in connection with the transfer. But again, it's a very, very specialised area of law, so you have to take advice from an employment solicitor. You can't, for example, cherry pick the ones you're going.
Yes, you can't choose who you want to get rid of.
No, you can't. And obviously, a lot of people in these situations will want to get rid of the people who are coming over to them and retain their existing workforce. You cannot do that. That will result in an unfair dismissal. So, golden mantra: take advice.
Right. Now, earlier on, you mentioned when you were talking about what TUPE actually does, one of the main points was an obligation to inform and consult. Could you explain a bit more about that?
Sure. Both parties, the buyer and the seller, or the incoming and the outgoing contractor, are under an obligation to inform and consult either a recognised trade union or employee representatives over any measures in connection with the transfer, or indeed if they'll be affected in any way by the transfer.
Okay. And what happens if I don't inform and consult?
Well, again, those employees who have not been informed or consulted can take a claim to the Employment Tribunal for that failure. This can result, depending on the severity of the failure, of up to 13 weeks uncapped pay award, and obviously that will apply to all employees. So again, it can result in a significant compensation liability for yourself.
Okay. And one last question, which concerns insolvency. Let's imagine, as an employer, I'm the owner of a business which is going into insolvency, and I have a company which is interested in buying my company. Does TUPE apply in circumstances like that?
There's very specific rules governing insolvency situations. The TUPE regulations were relaxed to allow an easier rescue culture, if you like. So the buyers of some companies in an insolvency situation do not have to take on employees or other obligations under TUPE. It depends on the nature of the insolvency. So if the company, for example, is in administration, and the administrators are from day one looking at a way of preserving the company and transferring it, if you like, as a going concern to a new buyer, TUPE will apply.
Okay.
If, on the other hand, the company is in liquidation, TUPE will not necessarily apply. So that encourages, if you like, people to buy businesses without having to take on all the liabilities in those situations.
Okay, this sounds like a very complicated area of law to me.
It is very complicated, and at Just Employment we're quite lucky in that we can give specialist advice on that very specific area of TUPE law.
Okay, so as an employer, your advice would be that I should absolutely, definitely take specific specialist advice about this before I do anything?
Yes, definitely. I mean, even solicitors find TUPE complex. It's a complicated area of law, and the tribunals sometimes struggle with it. And it's very much case law driven. And obviously, we as solicitors know what the cases are. You won't necessarily know them as a non-lawyer. So I would really advise you to take specialised advice.